In this part of the lecture, we're going to look at the major trends in international public law. What's happening in international public law now? Well, as I said, the dominant trend, and the one that is there throughout the last 100 years, is we have moved from a system based on natural law to one based on positivism. We moved from a system based on customary practice, and we'll talk a lot about custom in the next lecture, to multilateral treaties. Treaties not only between two countries, but large-scale treaties. Treaties that resemble the law. And we've moved from that system of what is the custom, for instance, freedom of the seas, to a multilateral treaty. In this case, the relevant would be the United Nations Convention on the Law of the Sea, which wrote down many of those ideas of custom that we got from the natural law principle of freedom of the seas. We know that the state has declined in importance. Although it remains important, it's the primary means of governance, but it has declined in importance. We know that the world has changed from a decentralized system of a small number of states to a more organized system of global institutions, meaning both states and international organizations. We move from a state-centered system to where now the actors are of a much wider variety. And again, we went through that before, all of the non-state actors that are playing an increasingly large role. And I think really you could look at social media and the idea that we are now organizing ourselves not along state lines, but along beliefs, lines of belief. Then you could argue that social media is in many ways taking the role of a state, roles that used to be reserved for a state. We know that the world has changed from states having the freedom to use force as a means of public policy to a basic principle of non-use of force, however, subject to the idea of the humanitarian war. And finally, we come to that last question, and this is a question that's going to govern much of what we talk about this entire semester. Is international law really law? Is it law, or is it simply imaginary? Now, there are different perspectives to determining whether international law is really law. Meaning you can look at it from 3 different viewpoints and find reasons to support either conclusion. We start with a positivist perspective. Remember, the idea of a positivist is there's a sovereign that issues commands and then backs up those commands with a threat of sanctions. Well, obviously that doesn't exist in an international concept. In an international framework, there is no international sovereign. And even if there are international laws, there's very little means of enforcing those international laws. So you could argue that from a positive perspective, international law is not real. It's not really law. However, we have a situation in which we could argue that people can voluntarily bind themselves to a set of rules or a set of principles. And in doing so, it is as if the sovereign is issuing the command. So for instance, in the European Union, there's a body of EU law. However, that EU law is also domestic law. So EU law is the law of France and the law of the Netherlands and the law of Croatia. That it is a sovereign law. It's domestic law. And it's the same in the United States. International law can be domestic law. So from that perspective, there is positive law that supports the idea of international law as really law. The sovereignty perspective is somewhat related, which is to say that sovereignty perspective relies on there being a sovereign. And of course, in this case, we don't have a sovereign. But again, if we cede power to an entity, for instance, the United Nations, then that United Nations has some elements of sovereignty. So use it either way to prove whether international law is law or not. And finally, the enforcement perspective. We know that there is no means of enforcing international law. However, the parties can agree to it. The parties can agree to be bound by the results of a trial or an arbitration, and in that case, there is enforcement. We know that the United Nations has a judicial branch, and that branch has powers that are similar to the judicial branch of the United States. So there is that aspect to it. So in conclusion, what do we learn today? There are different philosophical bases for international public law. We have talked about the history of international public law, this growth and development of international public law. And finally, there are arguments why international law is actually law, and there's also arguments why it's not. And so that's it for this lecture. Thanks.